Hey guys, how y'all doing today? If you've been here before, you know who I am. If you're new here, my name is Barb from Halfway to Sane. Appreciate the fact that you're here and listening. I'm going to go over some more Bryan Kohberger news. It has to do with the time of his arrest at his parents' home. So there are new developments in the Idaho College murder case as defense attorneys are challenging key evidence that they say was improperly obtained by police, including search warrants and DNA. New court filings from Bryan Kohberger's defense depict a chaotic night when the former PhD student was arrested at his parents' home in the Pennsylvania Poconos. I'm sorry, guys, my dogs they don't listen. They bark over everything. His lawyers claim that during the raid, law enforcement broke the front door of the home, shattered the sliding glass door of the basement, and held the entire family at gunpoint. They also allege that while Kohberger was zip-tied at his hands and surrendered by police at gunpoint, he made statements to his arresting officers despite not having his rights read to him. Well, that should be on him. Now they want those statements thrown out along with other key pieces of evidence lead defense attorney Ann Taylor argues were illegally gathered by law enforcement using his genetic information. Authorities linking Kohberger to the crime after they say they found DNA that was a statistical match on the button snap of a knife sheath at the crime scene. When law enforcement uses that positive match and then says, well, we need to go and get a search warrant because we have a positive match for Bryan Kohberger, that the DNA evidence is tainted and anything comes from it is fruit from a poisonous tree. The defense, who says Kohberger is innocent, claiming without that genetic information there could have been no request for his phone records, which prosecutors also say implicate him. Well, number one, he made statements on his own. He's a freaking PhD student in this field. He knows not to open your mouth and implicate yourself. So if he did that, that's on him. That should not be thrown out. I'm sorry. And as for the evidence, if it proves he did it, it should not be thrown out. Any freaking person in prison can say, oh, that's not mine, I didn't do that, and then ask that the court throw it out. Hell no. Hell no. They are also challenging the way authorities gathered search warrants, especially pertaining to the search of Kohberger's car, a white Hyundai Elantra, as well as his Apple and Amazon accounts. They say the warrants lacked probable cause. His defense alleges Pennsylvania law enforcement violated his Fourth Amendment rights by going into the house without a valid local warrant, noting the Idaho warrant couldn't have given them the proper authority. Now, the definition of the Fourth Amendment is as follows. The Fourth Amendment of the U.S. Constitution provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The ultimate goal of this provision is to protect people's rights to privacy and freedom from unreasonable intrusions. Well, I don't consider it unreasonable. They're saying he massacred 4 people. I don't consider that a unreasonable intrusion to his home when he's being accused of 4 different murders. It's not unreasonable. However, the Fourth Amendment does not guarantee protection from all searches and seizures, but only those done by the government and deemed unreasonable under the law. To claim a violation of Fourth Amendment rights as the basis for suppressing relevant evidence Courts have long required that the claimant must prove that they were the victim of an invasion of privacy to have a valid standing. The defense goes on to claim federal and Pennsylvania law enforcement violated Kohberger's rights by not knocking and giving him the opportunity to surrender. Well, if they would have knocked and tried to give him that opportunity, they don't know if he's got guns in that house, what he's capable of doing. You don't give him the opportunity to go get possibly firearms or something else to try and defend himself. This bullshit. The attorneys wrote law enforcement did not Mirandize him immediately, and 2 conversations took place before Kohberger was Mirandized by police at the station. Again, that's his freaking problem. He's the one who opened his mouth. He knows. He knows. Lawyers for Kohberger have accused investigators of an overbroad attempt to build their case, arguing their search warrants cost too wide a net. But prosecutors responding to the defense's lengthy series of motions posted on November 15, 2024, contend that taken together with other elements of the case, their probe for evidence was sufficiently particular and valid, and considering the information available at the time, the Moscow detective seeking the information could not reasonably narrow the scope further. The warrant must allow the searcher to reasonably ascertain and identify the things which are authorized to be seized. She added, broad language may be permissible where the warrant constrains the search to evidence of a specific crime. The rationale is that criminals don't advertise where they keep evidence. Exactly. And since the potential evidence they sought could be located in multiple formats and areas, particularly electronic data, prosecutors here said a wide enough investigative aperture is necessary. Applied to electronic devices, criminals can and often do hide, mislabel, or manipulate files to conceal criminal activity, such as that. A broad, expansive search of the devices may be required, prosecutors wrote, again citing legal precedents. Now, the seizure of items was limited to the crime Kohberger is accused of committing in the killings of Madison Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapman in their off-campus home. And though Kohberger has a right to privacy, that right does not shield criminal conduct, prosecutors said. In fact, it is because he had that right that they sought and obtained search warrants. Though the man accused of stabbing of 4 college students indeed had a reasonable expectation of privacy in his vehicle located at his parents' residence, and there was substantial probable cause to search it. And Kohberger also had a privacy interest in his AT&T account and phone records. As such, the state sought was granted and a search warrant to review those records. The filings were accompanied by a series of requests to seal corresponding exhibits meant to holster prosecutors' arguments. Prosecutors did not include the filings an extensive address of Kohberger's challenge to DNA evidence or the search of his Amazon account. Yeah, I have a hard time with the way laws are written. I don't understand why these criminals are giving more rights than the victims. And I don't care. He doesn't have a right to privacy. He doesn't have a right. He shouldn't have any rights right now at all. Granted, he hasn't been proven guilty. I believe he's guilty. That's my opinion. You guys can leave your comments down below. Do you think he's guilty? Do you think he's innocent? Why? Let's chat. That's all I have though. So guys, if you haven't done so already, please respond to you know what I mean. Join my channel, hit the thumbs up button and that notification bell so that you know the next time that I upload a video. I would greatly appreciate it. Till next time, guys. Peace.